Hi, welcome to the Retail Lawyer. Today's segment, or this segment, is going to be about independent contractors. As I've mentioned, I work with a lot of retailers, but I also work with a lot of small businesses across various industries. And one of the main questions I get asked all the time, or that comes up through the course of our conversations, is about the classification of employees versus independent contractors. There is a lot of consideration given and a lot of desire to work with workers on an independent contractor basis as opposed to an employee basis. And there's obviously advantages and disadvantages, and I'm not really going to talk about that. I want to talk to you about how to protect yourself if you decide to work with independent contractors, okay? So independent contractors, you'll hear them referred to as consultants, you'll hear them referred to as 1099 workers, whereas employees are W-2 employees. Withholding of taxes happens for the W-2 employees. 1099s get a 1099 and they got to pay their own taxes, that kind of a thing, okay? So, in certain industries, retail in particular, like designers, it's very commonplace to work with independent contractors. What's changed in recent years, it's funny because there's opposing factors going on. There's this growth of the desire to work with independent contractors, and for workers to be independent contractors, people like it. They like the flexibility of it. So there's a growing trend, so much so that we've coined the phrase gig economy, right? We've all heard that in the last 10 years, and it's growing. On the other hand, states and unions have gotten very unhappy with the growing gig economy and the growing idea of independent contractors. They're fearful, rightfully or wrongfully, they're fearful that workers are being taken advantage of. So there's been a lot of push for unionization in various industries, but more so, and to the point of this conversation, there's been more push by state legislatures, to put in restrictive language in their codes, in their labor codes, regarding the classification of independent contractors. California infamously has their AB5 law that's out there, and Uber and different ones are fighting that. New Jersey adopted a law very similar to AB5. Governor Cuomo here in New York has mentioned wanting to do it, but actually he didn't follow through with it yet. He might as time goes on, so we have to see. And there's been other states across the country doing different things. Florida, for example, they, within their labor code, I thought it was very interesting when I was looking at it, they have put in provisions about drivers, specifically thinking about delivery men, Uber drivers, TaskRabbit guys, Instacart, all those guys, all those people, I should keep saying guys, all those people, all those workers, and how to treat them and how to make sure that you meet the standard that they really are independent contractors. And I think Florida's law is looking to facilitate the gig economy, whereas California and New Jersey are looking to restrict it. So there's different approaches, and there's everything in between depending on the state you're in. A lot of states don't have any legislation on this yet. I think that's going to change. New York is one of those states that does not have legislation right now. You have to look at case law, and it's very specific, and it varies because it's fact specific is what I meant to say. So, but I want you to keep this in mind, because the big mistake that I hear from a lot of businesses and a lot of business owners is, well, the worker said that they are an independent contractor, and we both put it in writing that they're an independent contractor. Okay, that's really well and good, but that doesn't change the fact that if the Department of Labor comes in, or this supposed independent contractor files an unemployment claim, workers' comp, somebody gets injured, workers' comp gets involved, the IRS takes a peek. If they disagree with your assessment, it doesn't matter what you and that employee and that worker, I shouldn't say employee because that's sloppy language, that worker, doesn't matter what your arrangement is with them, because the government is going to look at it differently. The government and its agencies, whether it's state government or federal. And if they decide that it's an employee-employer situation, it is, whether you like it or not. And then you, employer, business, are going to be subject to fines and penalties and back wages and back taxes and contributions towards unemployment. It gets very expensive. So I want you to think about this very clearly before you engage a worker as an independent contractor. I'm going to give you some general basics, and then I'm going to give you some very specific tips that are going to be helpful to you. Practical. Okay, so generally, and again, you want to look at the federal law, which isn't really there, your state law, municipal. So if you're in a big city, you want to check your city to make sure also. So like, for example, New York City has the Freelancer Act. And within that, if generally speaking, if the independent contractor is anticipated to earn more than $2,500 for the project or the course of the engagement, the contract's supposed to be in writing. And they're supposed to be assigned writing, and they are protected by the local human rights provisions in terms of discrimination, retaliation, etc. So keep that in mind. But everything is different, so you want to think about that. So, and the IRS has standards that they issued as well. So you want to look at the different standards depending on where you're located. But here are some basics to think about, okay? All right, so, and again, as usual, I have the little one-pager that kind of sets some of this out for you that you can think about on your own and bring to your attorney to discuss and put the proper paperwork in place and make sure that you're protecting yourself appropriately. You can get this one-pager by messaging me here on YouTube, on LinkedIn at The Retail Lawyer, on Facebook at The Retail Lawyer, and I've actually just started a Gmail account, theretaillawyer@gmail.com, so you can kind of get me any which way. All right, so the basics, scope of work. What kind of work are they doing? Is it project-based? Is it kind of everyday work that your business does? If it's everyday kind of work that your business does, you might have some issues. If it's project work, like, hey, you know, like, so for example, I'm a law firm, I bring somebody in to do some marketing for me. That's not really part of my business, so it's not surprising that I would bring somebody in to handle that for me on a project basis. Within the retail industry, for example, a good example is you may have a marketing team within your design group, within your business, depending on whether you're retail, fashion, et cetera. But you probably have somebody who does some level of marketing, but you might want to bring somebody in on a project seasonal basis for lookbooks, to put your lookbook together, to put seasonal designs together. Maybe you're bringing in a designer who specializes in outerwear. Well, you don't need a designer who specializes in outerwear in the summer. So maybe you bring them in on a seasonal basis. Well, you would for the summer because of the timing to place the orders and all that, but you know what I'm saying. So you kind of think about, what are they only working on a piece? What's the scope of work? Does it make sense? If it's really an integral part of your business, be careful. Okay, who controls the schedule? Do you say to them, hey, I need you here 4 hours a day, and these are the 4 hours, and it's every day? Or do you say, I need 20 hours a week? You let me know, and let me know on a weekly basis so that I understand when you're working on our projects, or when I can follow up with you, that kind of thing. Are you providing the equipment, or are they providing the equipment? Do they have special licensing or education on their side that works on their favor? So, you know, maybe they do CAD drawings for you in terms of you building out your stores, but they just do that. And so that's a separate thing. Maybe they do technical packs for the design piece of it. Again, I'm talking retail because, you know, the retail lawyer. They do just the technical packs based on designs that you send out to them, but you didn't educate them and you're not providing them the software. That works in your favor, that it's an independent contractor. Are they sending invoices on a regular course? Now, here's the thing about invoicing. Invoicing is very important that one is sent. If they're getting paid the exact same amount, no matter what work they're doing on a you know, like let's say they're getting paid every 2 weeks, which is the same cycle, by the way, as your employees, could be a problem. If they're getting paid the exact same amount every payroll cycle, that could be a problem. So if they're detailing their hours and it changes because they do different hours during different weeks, or the invoice details different services that they've done, and it's not just, hey, you know, retainer blank. Think about that. You want things documented the right way to show that there's a difference between just a regular employee. The type of payment, so that ties into the invoicing, right? So are they getting paid at the same cycle as your payroll? Are they getting paid at the beginning, a deposit at the beginning, and then maybe a progress payment, and then upon the deliverable, they get the bulk of the payment? That kind of thing. Is it per unit as opposed to per hour? That kind of thing. You have to think about that stuff. Again, this goes back to, is it project-based or is it the everyday kind of work? That red flag. And where are the services being provided? Are they coming into your offices to do this work? Or are they doing it remotely and kind of sending it in? Do they have their own offices? Can they do it wherever they want to do it? Do you insist that it's done a certain way in your space? The control aspect is very important. So the more control the business has, the less likely it's an independent contractor. The less discretion the worker has, the more likely it's an employee and not an independent contractor. So think about that. Now, I want to roll this back away from technical kind of stuff into very practical advice. Okay, so I've dealt with a few of these Department of Labor audits that have come down. And I want you to know the Department of Labor audits are not usually triggered by the independent contractor. Usually there's something else that goes on. So for example, I had a situation where a worker in a different division of the company had issues and put in an unemployment claim wrongfully. And that unemployment claim, we eventually straightened that all out that no, this was a 1099 independent contractor. We proved it, we won that. The problem was, as that was happening, information requests were not being addressed properly on the other side of the business. And an audit started that was triggered by the first one that we cleared up. And the secondary audit, unfortunately, uncovered some issues. It happens. So, practical stuff. Does this independent contractor sign on as an individual, or do they have a business entity? You are better off if they have a business entity. They have an LLC or a corporation, much better off if they've got that. Do they advertise? Do they? And it doesn't have to be a billboard. It doesn't have to be in industry magazines, although that's helpful. Both of those. It could be social media on Facebook. It could be that they have a business Facebook page offering their services to other people that way. It could be that they have a LinkedIn page offering their services to others. They do posts occasionally. Whatever it is, if there's some level, a business card, things like that are going to be very helpful in proving that they have an independent business, that they're not reliant just on you, the business owner, this current company's business. You're not their sole client. If you are their sole client and all of their income comes from you, that's a harder argument to make that they're an independent contractor because they rely so heavily on your company. So you want them to have other clients. You want them to have, if possible, general liability insurance. Now that one to me is tricky because I've worked with a lot of independent contractors over the years and they don't always have it. So if you can get them to get it, great. And if you can't, have them focus on the other things. Make sure that they have a business set up, make sure they're advertising, seeking other clients, make sure they have other clients. Within your documentation, put these things in that it has been represented to you that they are a freestanding business with other clients and they advertise seeking other clients. That helps. Nothing is a slam dunk when it comes to the law, but these are things you can do to protect yourself. Do they have the ability to turn down assignments? That gets back to that control piece, right? So you can see that there's some very practical things that you can do. Make sure you document everything. Make sure you get a signed writing with this independent contractor and protect yourself. If you're careful and you protect yourself, you can work with independent contractors. Nobody's trying to scare you away from that. Just as when you're working with employees, there's certain things you need to do. You know that, right? When you hire an employee, you have to get an I-9 filled out. In New York, you have to do a theft wage notice. You need to you give them the employee manual, and you need to do sexual harassment training. You need to do a lot of different things. Well, with independent contractors, there's standards as well. So depending on which one you're going, just have that checklist ready for yourself. These are the things I need to do if I'm working with an independent contractor, and these are the things I need to make sure are accurate. And then these are the things I need to do for an employee, and I make sure, again, accurate. And then you follow accordingly. If you do so, you're going to be fine. But check with your counsel, do job descriptions, very important. Document. Protect yourself, documentation. So many people are afraid of documentation. Don't be. In the end, documentation can help you as long as it's done correctly. So good luck to you. And, work with your independent contractors. Keep that gig economy going, especially now that more people are interested in remote work. This may be more of a growing opportunity. And thank you.